In this live, I will be providing latest UK visa updates and also provide brief answers to your questions about UK visa applications, including EU settlement scheme and British citizenship. I will prioritize in this order. First, live questions with the priority for channel members and then others. And any comments, and in the comments also which are already on the channel being asked as questions, priority to members' comments and then others' comments. If you stay throughout the live, I will be giving important UKV updates throughout the live. Uh, and also, if you stay towards till the end of the live, in this live, I'm going to talk about three things. I'll be sharing important updates about these three things. For which industries Home Office will require additional information when a DCOS request uh, when a DCOS is requested, which are the main industries that Home Office is usually concerned with. For these types of industries, they always request additional information. Second point I'm going to talk about towards the end is the specific concern that Home Office has with the chef job code 5434. And the third point is if a PBS application is refused, which option is better, either to file an administrative review or to file a new application within 14 days. So these are the 3 points that I'm going to cover towards the end of this live. So if you stay throughout this live, you'll get that information. And so who is this live for? Every UK visa has its own challenges. I will equip you in this live for those challenges and take you one step forward in your UK visa journey. Introduction about myself. I am Sachin Sawant, UK immigration lawyer, registered with the OISC at level 3. I do advocacy and appeals, first year tribunal, upper tribunal, yeah. So almost everything. Then, okay, so I've covered the introduction. If anyone coming live has any questions, they can ask me them now. Hi, Mahmouda. Till the time the questions come, I'll go into the YouTube comment section and check and answer any questions over there. I have not responded, and let's sort with members. Members. Okay, no channel member questions. Okay, so I'll just take the questions in the order the latest ones received. So I have a question from Ramakrishna. Sir, I'm holding skilled worker visa. I'm getting 26,500 in the salary. So can I bring my wife and 2 kids under 18 years? So the question to be asked is, if your job code is one of those care worker job codes, and if you got the visa after April this year, after 4th April, then you cannot. Other than that, you can. So if you got the visa before April changes, or if you're not in one of those job codes, whether you got it now or before, doesn't matter. So the only problem is if you are in one of those care worker job codes, 6135, 6136, I think, and you got the visa after 4th of April, your course was issued after 4th of April 2024, then you cannot. On other cases, you can. Benga, your live question. My family and I have applied for graduate visa since 30th of December. It's yet to be concluded. So my last child just had hers today. Your last child has hers today. I don't understand. So do you mean to say one of the dependents is decided before the main applicants is decided? So your family and you, so main applicant and some dependents have applied, but no one got a decision. Only your last child got a decision. So the decisions may come through if just one of the dependents has flown through the system. Sometimes the decisions don't flow through the Home Office Atlas system. So they should come shortly after. If my last child did her own today, your last child did her own today. So what is your question? If your question is if you not received a decision since 30th of December, have you filed priority? Graduate visa do have priority? No, I don't think you have graduate visa priority service because it's not you are doing through the app. You filed standard service 30th of December. If you submitted, then you should be waiting for at least 8 weeks period. I think that is the processing time for standard processing. What is the service you have used? If you tell me that. By the time I'll take another question. Can you please post the website link to where the NTL application is made? So sorry, in this live I cannot give application links and all of that. For that you need to book a paid consultation. All the links are there to book the consultation in the description of this video. Next question I have, I got sponsorship in 2023 December. Now I want to change my employer. What salary condition applied to me? 2023 you got your first skilled worker as well. My dependent can switch visa with me or not? Okay, so you got your first skilled worker visa in 2023 December. So I want to change employer. What salary condition? The base rate will apply to is 29,000. At the time when you applied, the base rate would have been 26,200. Now the base rate will be 29,000. That is the only change. As well as my dependent can switch with me. Yes, your dependents can switch, but if your dependents already have a valid permission, you don't need to apply for them now. If they have a longer permission, then you can just switch the employer, file your application, switch employer or switch job code, whatever you are doing, and that's it. Your dependents can continue living on those dependent child, dependent partner, whichever those visas are. They need not apply along with you. It's not required. I know people do it, but it's a waste of money. So you can wait till the end of their visa. In the last 28 days they can apply themselves. Okay, I haven't got any live question yet. Let's take the channel one. So another one on the channel, Lijit, I've applied e-visa but I could not scan BRP. Okay, still I skipped that step and followed other steps. You did not scan your BRP, you followed other steps. Still I didn't get my e-visa confirmation mail or anything. What shall I do? I think if you don't scan the BRP, how will the system recognize you? I know the system does say continue with it, but I don't think you will get an e-visa that way if your BRP is not scanned properly. It's impossible for the system to collect your biometrics unless your BRP is scanned. That's the only way it will link the biometrics and take it into that UKVI account, into the e-visa after the UKVI account. So yeah, maybe you should contact the UKVI helpline. If you Google search for e-visa web chat UKVI, there is a web chat. You discuss with them your problem and they should be able to help you with that. Would these apply to children of EU nationals, please, who are not nationals themselves? Okay, I have a live question. Mahmouda Khanam, can I describe to Home Office that I didn't complete my course within time frame because of my health issues, pregnancy, as I have a receipt on 17th of January. Visa will expire. Can I describe to Home Office that I didn't complete my course within time frame because of health issues, as I have a receipt on 17th January, will expire to results on 10th March. On which application are you suggesting that you are going to explain to Home Office? What application are you proposing to make? First tell me that and then I can answer. Home Office will not just look at letters that you send to them. Anything that you want Home Office to consider, it always has to go through application. So which application are you proposing to file? First you tell me that and then I can answer your question accordingly. Okay, next question I have here. Okay. So this question is on auto upgrade from pre-settled status to settled status. So I think there is a video that I have made for auto upgrade information regarding that will not apply to family members, usually partners, spouses, etc. Auto upgrade of pre-settled to settled only applies in case of the EU national themselves. So the question Samson has asked is, would these apply to children of EU nationals? Please, children of EU nationals who are not EU nationals themselves. Children of EU nationals who are not EU nationals themselves. I think they may not apply if they are EU national children who are not themselves EU nationals. From what you are trying to suggest, I don't think it will apply. I understand what you are trying to suggest. I don't think they may automatically extend because I understood the question properly, but my simple answer is I doubt whether the pre-settled status auto extension, auto upgrade to settled status may or may not apply. Okay, so there are some live questions. Let me take that. PSW. So you are going to file a graduate route application, and in that you are going to tell them that you did not complete the course, you have a resit, and this. So I didn't complete my course within time frame. So we have to look at it, what are the requirements and what is the purview within which a caseworker can work on a graduate route application. So just to see, I don't think they have any discretion to allow resits or health issues or anything like that. If it's a human rights application, it's a different argument altogether. But under the points-based system, whether it's a skilled worker visa, student visa, PS graduate route, global talent, there is not much discretion for caseworkers to allow things on other grounds. It is a difficult one. I'm not sure what you mean. If you tell them they are not, why would you tell them? Because when they pick up the application, they would try to see that the course is completed. I don't think, I don't know why this explanation would be relevant when they pick up at that point. Sorry, I'm not getting what you're trying to say over here. Okay, Aves, sir, I asked in previous live, I have been given a DPG diploma, but I did not pay remaining fee. If university allows me a full-time work and student duration is complete and status is okay. Okay, will Home Office ask for fee submission? I don't think Home Office will ask for fee submission, but I'm not sure whether you have successfully completed the course of study, whether you meet that definition. So, yeah, I don't think they will be asking the uni whether you have paid the fees. Payment of fees is a private matter. You have a private contract with the university. You and the uni are the contracting parties. So, I don't think Home Office has any recourse in asking such questions. They don't even have rights, so that's a private matter between you two. But if your uni has already debarred you, or they may not have reported, but if in their systems they have already declared you as a defaulting student, whatever they call it, I don't care, non-bona fide student, that may lead to them you being not completing the course of that is what the uni may confirm, that you have not completed, you have stopped the course at some point, whatever that is. So I don't think universities will give a positive response if their fees are not paid. I'm quite positive on that, because they are in a business. So, but Home Office cannot ask. If that is the question you are asking, I don't think Home Office asks unis, have you paid the fees? They don't care about it. That's a private matter. So, Noman Siddiq, how long is Home Office taking to issue healthcare defined cost these days? Maybe up to 3 months or so, I think so. They do a lot of investigations. Wait till the end. I'm going to discuss on some of the industries that are the high risk ones. Home Office always asks additional information. So I may discuss some things on that point. Guman kids. My visa was rejected because of 7 months of overstay. After rejected my visa, I left the UK within 1 month. Any ban on me because I have a new visa and want to apply? Because 7 months overstay. 7 months overstay will definitely lead to at least 1 year of ban. So I think 12 months, more than 3 months of overstay would lead to 1 year ban, to the best of my recollection. Okay, windswept Canadian. Yes, I remember you did ask some questions in previous lives. Okay, thank you very much. Just got your ILR. Congratulations on getting the ILR. Yes, thank you. Okay. So yeah, someone has just reported. I think, I'm sure, windswept. I remember this name. You had asked some questions in the past in some lives, and now you got your ILR. Yeah. So this is, as I say, people do benefit from this. You save a lot of costs on advice and all. Yeah. So do subscribe, at least prefer becoming a member. Most of that money goes in, all of that money goes in donations and all. Okay, there is some £1 or £2 memberships. You can find it on the channel information. Okay, no more advertising here. Let's take the next one. Hi sir. So next question from Mariam Baby. Hi sir, I want some info for administrative review. क्या administrative review से वीज़ा सच में आते हैं? बस एक familiarity. Okay, the question is from Mariam Baby. I think her application is refused and she's asking about, does admin review make sense? So admin review only makes sense where you can expect something out of it is when you are expecting. So what is admin review? If I'm the caseworker, I decided I refuse the application on whatever grounds. My colleague sitting next to me on this chair will look at the case and see if I have done anything wrong. So if I have not done anything wrong, and the wrongs, for example, the wrongs would be you submitted a bank statement. I'm just taking an example here. You submitted a bank statement for financial requirement, 28 days, and whatever, one page was missing, or one page was there, but I did not look at it. But I said, oh, you did not submit all the pages of your bank statement. Let's say 2 pages bank statement. I only looked at one and I said, oh, you did not submit the second page or all the pages of your bank statement. But that was my mistake. So that person is only going to look at that, and if a mistake like that comes up, yes, that can be overridden. That is an example. Another example would be if you gave the English language test, but I ignored it for whatever reason, it didn't come through the system or whatever that is. I didn't see it. You had provided it already. Then that person looks at it. He sees, okay, it is in the evidence, but I forgot to look at it for whatever reasons. Those are the cases, administrative mistakes. Think of it. The name is administrative review. It's not an appeal. Not a judge is not looking at it. Just another caseworker is looking at it and trying to see if I did any administrative error in deciding the application. So if you think there is something like that, only then file admin reviews. Other than that, there is not much hope with admin reviews. Okay, so next, Surajit, on bail 201 after advisors made second fee waiver. You're still making fee waivers on bail 201, which isn't allowed. Have pending skilled worker September 27 invalid cost. HRO November fraud victim, no updates from HO. Sorry, you've given too much information. I know it's something bail, then you are making fee waivers. You are just trying to buy time in the UK, looks like to me. Have pending skilled worker. I don't know how you would have a pending skilled worker when you are already on a bail. Speak to an immigration lawyer. Your case looks complicated. I know there are 5 or 6 different points that you mentioned. Information is required on all of them. If the order of events is you got bail and after that everything else happened, whatever you stated that, there is not much hope. So that's what I can say. But yeah, speak to an immigration lawyer, take proper advice, and yeah, this is not something I can give in 5 or 10 seconds. Sorry about that. Okay, next question on the channel. Pardeep, I'm going to travel from Toronto to New Delhi on January. I'm connecting flight. I have to stay 5 hours, London airport. I have an Indian passport, work permit, do I need ETA? So yeah, Indian citizens don't need ETA, don't qualify for ETA, electronic travel authorizations. That is for non-visa nationals. For example, an American, an Australian who does not need a visa, for example, a visitor visa to enter the UK. They just enter the UK with their passport. They are given visitor on entry. So if you are an Indian citizen, you don't need ETA, but you may need, what is the other one called? Yeah, there is another visa that is, I forgot the name of that one. What is that? Okay. Yeah, you don't need an ETA. So if your question is you need an ETA, I don't think you need an ETA because you don't qualify for ETA. ETA is only for non-visa nationals. Okay, so hello Babakar. Yeah, okay. I think some questions are flowing through. I'll wait for them. Let's refresh over here. Okay, the next question I have. Please advise, can I apply for human right on the basis of family visa? Can I apply for human right on the basis of family life on a visitor visa? Currently, I'm on a visitor visa. Human life. Unless you have a case, I don't know the facts of your case, if you are the parent of a British child or whatever that is. Unless you have a case, can I apply for human rights? The question is on the basis of a family life on a visitor visa. Family life. I don't know what family life you are referring to. If you're just saying some family member is here, I think the only option would be if you have a child who is British or born and lived in the UK for 7 years. On that basis, you may be able to switch. Other than that, you may not be able to switch on to MLE, any family visa from a visitor visa. Summary to answer that. Okay, what is happening with my internet? Okay, I have some questions. Let us see. Hello, Babakar. Greetings. Mahmuda. Okay, sir, as you calculate reasonable time for PSW application and individuals apply before visa expires. As you calculate reasonable time for PSW application and individuals apply before visa expires pending receipt results. Does it still apply in such case? You calculate reasonable time for PSW. Yeah, so if you're asking for, you are doing whatever resets for whatever health reasons you had, you failed your course or you are doing a reset and you are trying to do pending results, it is a tricky one. I would always advise to do it through immigration lawyers. You can do it through us or any other immigration lawyer. Don't try doing it yourself. I have had people, I know you can put that reason, you can file it yourself, I don't mind. But many people who have done it themselves have got refusals. I know that for a fact because many of them have reported. I cannot tell you to do that, then you file it and yourself and then it gets refused. I cannot do that. But then always do such applications through immigration lawyers. It may be possible, it depends on the facts of your case. From the dates what you said, I think it is possible. But always go through a legal representative. You can come to us or go to anyone else, doesn't matter. But do it through a legal representative. That's my suggestion. Doing it yourself is risky. And I've heard several of these are on last live also. I think I reported someone who did it himself something and it was refused. The university did not send a notification. I think that person even passed everything. He didn't even have a reset. In spite of that, it was refused because the university did not send a notification. So all of these pending receipts and all, please do it through legal representatives. I was on a graduate visa before. Surajit. Yeah, that is fine if you are on a graduate visa, but yeah, I noted all the information that you put there. Just being on graduate visa doesn't change anything of those facts. Team Wakanda, my agent used a fake financial statement. Is it possible to get banned? Yes, fake financial statements from agents is a very common scenario. I've seen maybe hundreds of such refusals where there are fake statements and home office alleges it's a fake statement and the applicant says no, I did not give it, my agent gave it. So who is to decide? It's impossible for home office to decide and those things cannot be overturned. Thank you, Mahmuda. Okay, Surajit expired. Okay, for my whole question. Okay, so your graduate route visa expired on 29 June 2024. All applications made by previous are met online except FLRO in under 10 days period. What should do? So are you currently on bail? Are you currently on bail? Simple. Answer that question and I will tell you yes and no. Yeah. Surajit. You should speak to an immigration lawyer. I already told you, but then yeah, yes, you are on bail, you cannot file any applications. There is no recourse. You have to leave the UK and file. You cannot sort it out in the UK. Whichever lawyers are telling you that you file this, pay them money, they are just making money off you. I can guarantee you that. You will not get sorted. I can tell you, you take my word. I know you may not listen to me, but that's your decision. Do we need to give pay slips for naturalization? Naturalization? I don't think so. Depending on what you're trying to prove, I don't think you need pay slips for naturalization. And Shimalan sir, how can I get appointment with you? We only offer paid consultations. The link is in the description. So hit the link in the description and you can book the consultation. So Anshi, Team Wakanda, passport came and there was no ban. How possible? Passport came and there was no ban. So what was the refusal? What is I don't know. If there is no ban and is your application refused? So what is your question? My agent used fake financial statement. Is it possible to get banned? Yes, it is possible to get banned if Home Office finds out that it is a fake statement. Okay, I forgot to set a timer. Let's set it. Okay, I'll give an update. Forgot to set a timer today. Let's start this one. Okay, thank you, Anshi. Okay, update time. So, usually one of the only professions that is allowed self-employment under the skilled worker route is this from home office update and experience. And that profession is usually dentists. Dentists on skilled worker visas are self-employed only. So this is a common practice, and that's the only area where self-employment is allowed. There may be some other professions, but usually it's very common only in dentists. Self-employment is allowed as a skilled worker. Self-employment is not allowed on almost all other occupations, almost 99%. On the dentist front, since that is the only one, hence Home Office has started asking some more questions on dentist job codes nowadays. This is a new thing that has started. Even in the past they used to ask, but now for DCOS requests they are asking additional information. So this is one of the industries that they have started asking more questions, because self-employment seems to be like self-employment is the main area that they are trying to see. Because Home Office, this was queried with Home Office, and about the more additional information being asked for dentist sponsorships. The Home Office further clarified that this is just a clarification from Home Office and information. There is no systemic concern in relation to dentistry. They are saying that they do understand that the only aspect the caseworkers are mindful in this context is the potential discrepancies regarding the self-employment arrangements. So they are not very, they want a proper clarification on the self-employment arrangement. Home Office confirmed that it was always a historic issue. That's what they are saying, but we are seeing that they are asking more questions nowadays, and not something the team is seeing now. That is what Home Office says. Uh, Home Office assured that DCOS requests for dentists are being processed swiftly, and while there may be occasionally be a request for additional information, there are no broader concerns from caseworkers. Besides ensuring that, so the main thing for dentists they want to ensure is sponsors understand self-employed arrangements and must comply with the sponsor duties, responsibilities outlined in the rules. And so that is the only update on dentistry. We have seen some questions coming through on these DCOS requests, but Home Office says it's routine, but we just expect that the sponsors, Home Office has been cancelling a lot of sponsor licenses. Yeah, we see that. So in this area also they've started asking, as they don't believe the self-employment arrangement is very genuine, or if the employer understands whether the self-employment arrangement they do understand with respect to skilled worker minimum salaries, etc. So yeah, this is something new that we saw, and that was the update that I received. Now I'll go back to the live questions. Where are the live questions? Okay, Suraj, if I leave the country and apply skilled worker visa from India, does that chance of rejection? It depends if you have overstayed any part of your leave. So I'm not sure what has that's why I was telling you. I know there are several things that have happened, FLRs, fee waivers, whatever you have done. All those timelines need to be calculated, and accordingly, if there is an overstay, yes, it will impact overstay of more than 90 days. Then you may have a 1 year ban. If not, the other concern that Home Office may have is if you tried several applications, I don't know, FLRs and fee waivers and all of those, one of the Home Office may investigate you left, right, and center, because that is what Home Office is not happy about, people doing all these fee waiver, FLR, and the new one that has come up is EU settlement scheme application, which is complete nonsense. Yeah, so these three Home Office is aware that people are filing just to buy time, and they are not happy. And if you've done two of those, which you did inform fee waiver and FLR, I think they'll just investigate you left, right, center on whichever job that you are trying to apply. That is the other side of it, if there is even not any overstay. Team Wakanda agent used a fake statement. I had to write to the embassy immediately, but no response. In few days, my passport came out, but didn't see a ban on it. But visa wasn't issued, Any advice? So what was the reason of refusal? If it was not for that particular statement, maybe you gave the correct statement and all, what is the reason of the refusal? Is it the statement? They clearly write down you gave a fake statement or you didn't give a statement, whatever that is. So look at that because of the bail and all these applications. Yes, because of the bail, not because of the bail, mainly because of all these applications that you have done. Yeah, they are called as frivolous applications. Even when we go to tribunals, when people file asylum, all these are just frivolous applications. When you don't have any merits, you are just making applications to live in the UK. Judges don't like it, home office doesn't like it, so that's why always take proper advice, and if there is no merits, yeah, it's better to leave the UK. But then, yeah, whatever has happened in your case has happened, we can't change that now. So okay, let's see, why is my internet not working? Let's change it. Okay, here I go, refresh. Okay, community, and I haven't responded. Okay, I have next question on the channel. No live questions yet. My PSW expires soon and I wanted to apply for FLR. Is this the right way to do? No, FLR is not the right way to do. Am I legally eligible to work in the extended time period? There are no more merits of FLR. I don't recommend FLR. So extended time, I wouldn't get into the discussion if I'm saying no to the application itself. If I extend once, can we come back to the UK or go to any other countries? I cannot advise on other countries' issues, but extending once, yeah, you're just trying to buy time. This is what I say no to, and yeah, I advise against filing FLRs just to buy time. Because I have filed FLR HRO, I have submitted my passport to Home Office. I can't leave the country. You can't leave the country. The way you leave the country is you call the voluntary return service. You Google search for is UKVI voluntary return service. You send them an e-ticket, then they give you the passport at the airport. So that's they arrange it. They tell you. You can call them also. That's how you return. So you go to the airport. They give you the passport over there. But once you book the ticket, you send a copy to that voluntary return service team, and then they send your passport to that airport when you are flying. And once you, yeah, before you board the plane, they give you the passport. That's how they do it. Okay. Okay, next question I have on the channel. Can you send a link where the rule says no absence letter needed from the employer? Okay, the question is on, so for skilled worker, indefinite leave to remain, I think there are 1 or 2 videos that I've made. You don't need the absence letter. I know it does come up on the application form, but the rules have changed. I've done several applications without that, and I told basically put a legal covering letter explaining that the rules don't require it. Just so the way the rules apply is, how the home office system works is, the rules are superior to everything else. The guidance or the form cannot add extra requirements. Before, in the tier 2 general area, before skilled worker, there was tier 2 general. At that time, absence letter was required. In the rules only it was there. But in the new rules for the skilled worker, whenever skilled worker was launched, that requirement has been taken out. Hence, for indefinite leave to remain, for skilled worker visa holders, you don't need the absence letter. So this person is asking, can you send me the link where it says no absence letter is required? You need to go into appendix FM, appendix skilled worker, and review the rules and interpret it. So I'm a lawyer, so that's why I'm interpreting the rules for you. And so if you want the proof of that, go into appendix skilled worker and review the rules. That's where you'll get the answer. Okay. And she said, my wife want to take sponsor on beauty line. What salary required beauty line as a skill visa? I cannot do any salary calculations on the lives. You have to book a consultation. I have to take all the job description. I have to fit it into a job code, see if it is eligible for a skilled worker visa, and only then I can do the salary calculations depending on your current visa situation. Everything, a lot of things apply on that. If you want to try calculating it yourself, there is a salary guide visa. It's a video there where I've explained different types of salaries and all what apply. You can try calculating over there. Okay, Master G, can a person work with his older employer in his new visa? Can a person work with his older employer in his new visa? In his new visa gets rejected during the employer change and needs to leave the country. Okay, so the question is, so I will clarify, I understood it. So you were working with employer A, you had a valid visa, you decided to change and move to employer B, you filed a new update your visa, what home office called, it's kind of a new skilled worker visa with employer B with the new, okay, update time. I'll do the update, I'll answer this one first. So if your new visa is not approved with B, if your visa with A is still valid and you have extended leave, you have permission, you can continue working with the current employer because he's still your current employer. No new employer sponsorship was not approved, so that is completely out of question. So you can keep on working with employer A in my example. Yes, you should if you have the visa valid with A. So let's see, do I have something? Okay, another update. So this is an update. So I also do appeals with the tribunals, and also there is a judicial improvement group through Immigration Laws Association. We have that. So from the first side tribunal especially, this is something that has been observed. So that's why I always say, always take proper legal advice from a qualified legal representative, number one. Number two, especially for appeals and all, please give it to a proper qualified one who you know that they will handle your case very well. This is a new thing that has come up. Usually they've done the numbers with the first tribunal, and this is what they found out. Around 20% of the legal officer outstanding workload. Legal officer is the officer who works in the tribunal. Their workload, 20% of the as of 30 relates to follow-up work. They are chasing either home office or the legal representative or appellants in person if they are doing it themselves, which are very less. Relates to follow-up work, chasing either party for a response or directions. This contributes to a significant amount of time chasing parties for overdue actions. And one of the things that have come up is 23% of time of that legal officers, the tribunal officers for your case, is following up with legal representatives for case building or hearing requirements, usually for documents, witness statements, appeal bundle, skeleton argument. So I draft all of those, so I know it does take time, but then this is not, there is something where I think people are giving cases to, I'm not sure whether those solicitors or whoever legal representatives they are not doing things on time. So if you are getting into appeals and all with the tribunal, things need to be done on time. So it is quite a high number. 23% of the follow-up time of that legal officer goes in all these follow-ups with legal reps. Rather, the legal rep takes money to do your job, and it appears that there are many legal reps who are not delivering on the promise, doing things on time. So get a proper legal rep if you are doing an appeal, and that's my suggestion. Okay, yeah, we do represent clients, we do everything on time, even before the court timings, everything is submitted. We are more before time in most of the stuff. Okay, so next question. Anshi, I'm on dependent spouse visa. Can I change my visa category just like I'm on a dependent spouse visa? Can I change my visa category just like, can I become main applicant? Yes, from a dependent you can become a main applicant if you want to. And but my visa on a skill visa is dependent allowed in construction skill visa. Dependent is allowed to switch into any skill visa provided everything is genuine. So Master G, thank you. So if you are a dependent of a skilled worker, I don't know what dependent, I'm assuming you're a dependent of a skilled worker. So you can switch and become the main applicant on a skilled worker. Job codes are not relevant. Okay, Ma, thank you so much for clearing my doubts. I have been in touch with a few immigration lawyers. They said I have to leave the country. Okay, what was the... No, if you have extended leave, that's complete nonsense. So I know if your other lawyers are telling you this, so I'll just take an example. Let's say you have been working with employer A, try and clarify more. You still have your valid skilled worker permission, let's say ending on 31st December 2025. You made an application now in January to change to employer B. That one was rejected, so you fall back on the previous one. So the previous one is still valid. It cannot be cancelled, obviously. So you propose that you wanted to change. That was not approved. For example, let's say that employer has some compliance issue. They lose their license. The new employer. That is not your fault. Okay, I'm just taking an example. So there are many reasons why that may be refused, but let's say they didn't have a genuine vacancy, something like that. So that refusal should not have, unless your current visa is also curtailed, which may happen if you do some fraud, buying, selling and all, they may just curtail all your visas. That may happen. But unless they have they have only refused the new visa application for B, the one that you already had with A, which is valid till 31st December 25 in my example, that should be valid till that date. You can still work for the previous employer. Okay. 10:04. Let's take another question. Okay, I have a question. So, you have a question. I'm extending EME, my visa. I have been on the old rule salary 26,200. Assume my new cost. Okay, long question. Reflected the new salary of 29,000. At which point will this new salary has to take at least a month before the starting of resumption stated on the DCOS, or the actual date of resumption mentioned on the actual date. So the question is, so EME is under the old rules on a skilled worker visa. His previous base salary was 26,200. That's fine. So now he is applying for extension. Obviously, his new base salary has to be at least 29,000. It cannot be 26,200. So he says that yes, at which point the employer has to pay this 29,000. The employer is legally required. They can pay it well before time. They can pay it from today. It doesn't matter. But the employer is legally required to pay the salary from the work start date that is mentioned on the cost, or if the work start is moved forward or changed from whichever is the work start date. So that is the answer. Okay, any live questions? Where is it? I see there is a live question. I'll just get into the live through my Mac over here. Go live. Where is it? Okay, Bridget. Good evening, sir. Please can I bring my 3 years son to the UK even if my husband license has been revoked? Husband license has been revoked. You have a dependent visa. It will be a tricky one. I think what will they do? They will check that you have a valid permission. It is a tricky one. They may refuse it. So if I have to, okay, strictly speaking, I know you can tell me the rules that yes, you have a dependent visa, your husband has a main applicant permission, but then they may refuse it also. There is a possibility of refusal. So maybe once your husband main applicant switches and gets a new employer, I would advise you attach the dependent at that point. You can bring that child at that point once your husband switches and he gets a new skilled worker visa with a new employer. So that is my suggestion. There is a chance it may be refused. Okay, so next question I have. Thank you, Bridget. Okay, hi, I'm 24 years old right now. I'm on dependent visa. If I switch dependent to skilled worker, then which salary requirement? 30,000. So if you are 24 years of age and you're switching, you're on a dependent visa, and you want to switch to a skilled worker visa, you can use the new entrant salary. Obviously, you are under 26 years of age. So the new entrants are required to be paid at least 30,960 if I'm not wrong, or the going rate, 70% of the going rate. Yeah, you look at the salary guide. There is a salary guide video where I've explained the new entrant salaries, how to calculate them. Can we study with skilled worker visa in UK? Skilled worker visa, you can do part-time studies. Remember that you can't just study full-time because you will be working full-time. You are expected to work full-time. You may be able to part-time study. So you need to work for the contracted hours with your sponsor. And my wife's study is not completed yet. I am on dependent visa. Can I convert my visa? My study is not converted. Can I convert my visa on skilled worker before study completion or not? Yes, you can. As per the immigration rules, you can. I know I have done it myself. I know I have represented several applicants and I have switched them in similar cases as yours. But I remember at least 3 or 4 have reported on the channel that when they filed it, the dependent filed, the caseworker send them, usually Home Office writes back, send them an email asking them to provide the course completion confirmation from the university. That does not make sense, but that has happened. Just to report, I know some people reported on the channel that the caseworker is asking for course completion letter of the main applicant when the dependent is switching, but the rules don't require that, and that is not in the rules. So yeah, you need to decide accordingly. Preferably do it to a legal rep. Yeah, that's my suggestion. Can I invite my 3 years son? Or it's not possible. Invite your 3 years son if you want to invite on a visitor entry. I'm not sure how you're going to invite your son. Please clarify. If you're thinking of visitor, I doubt even that should not be tried. Okay. Okay, so 46. Let's see. Next question I have, Eluj. May I ask, if the re-entry ban is finished, is there a chance to get skilled worker visa? Yes, if your re-entry ban has finished, and if your everything is genuine on your skilled worker application, your job is genuine, vacancy is genuine, you got it genuinely, there is no buying, selling, etc., your application will be considered on its own merits. And no doubt the previous re-entry ban will have, the only effect will it will have is that ban has finished. They would check you quite carefully, so they may interview you or something. But yes, if everything is right, you should be eligible, you should get it through if everything is genuine. But you may have to go through additional scrutiny. That's what they will do. I'm positive on that. And please tell me the minimum annual salary requirements for manager role in Domino's and post office. Minimum annual salary, I don't do salary calculations on lives. Yeah, it's a time consuming thing. I cannot do it in 10 seconds. You need to book a paid consultation and that will be done during that. Actually, okay, hello sir, actually I applied skilled worker visa from UK on course. They mentioned date 30th December 21 to 26, but my BRP 1322 to 27. This means 5 years finishing or not. 5 years finishing or not. First Jan 22 plus 5 27. I'm not sure why they've given you from 1st of March. It may be an application, it may be a decision delay. So maybe you got the decision on 1st of March. But if you are not on the skilled worker permission, you may be short of the total 5 years, it appears, because they've given you from March till January 22 to 27, which is less than 5 years. So I'm not sure what exactly has happened on your case, but you are short of the total 5 years, it appears, at least by 1.5 months approximately. So January, February, yeah, about 1.5 months you are short. But that, yeah, maybe speak to an immigration advisor at the time when your ILR is due. There may be solutions at that time, depending on the rules at the time. I cannot view my e-visa 3 months after a confirmation email that says I'll be contacted to know when I can view the visa. Do I continue to wait? Yeah, you should contact the Home Office web chat. Google search for web chat for UKVI e-visa. You will go through the e-visa help option. Under that, once you click and you answer the questions, it connects you to the web chat, and that's how you do it. Let me find it and let me put it over here if I can. E-visa web chat. Okay, let's check over here. If you need help, ask for help. Okay, so I will put it on this live stream. Okay, that is the link for the web chat. I have put it on the live. Yeah, you continue answering those questions and then it connects you to some human being. Okay, so 50 minutes. Okay, we are coming to the towards the end of this live. As I promised, I'll be giving 3 updates on 3 matters. I'll start with the first one. So the first one was which industries the Home Office will require additional information. So these are 1, 2, 3, and 4. So these are the 4 sectors where Home Office, every time you file a DCOS request, they will ask for additional information. Doesn't matter which employer that is, doesn't matter which sponsor that is. One is health and social care sector. A lot of abuse happened in that one. Construction sector, I think someone, Anshi or someone was asking. Construction, construction DCOSs will get questions. Fishing industry DCOS requests will get questions. Hospitality sector will get questions. These are the 4. Home Office themselves have confirmed to us that these are the high risk ones. We always send additional information requests for them, irrespective of the employer or whatever that is. Health and social care sector, construction, fishing, and hospitality were the sectors which also require additional information. So that is the first part. Second point, the specific concern about chef job codes. Usually Home Office has issues with the chef job code, which is 5434. The reason being, the job description that is given by the employer, by the restaurant or whoever is filing, the job description is more closely aligns with that of a cook. Cooks cannot be sponsored to the best of my knowledge, but chefs can be. So usually employers apply 5434 job code chef, but when they put the job description, they will put the job description of a cook. And Home Office is not happy with that. Obviously, when they look at the job description, they just see that the name is different, but it is a cook's job. And hence they do take it case by case. They look at every case, but this is a common thing that they see when requests come for chef job code 5434. The job description more closely aligns with that of a cook rather than a chef. So that is something Home Office has concerns with, and hence more additional questions are asked, additional information is asked to get a clarification from the employer. So that is the second one. The third one I wanted to address is the PBS application refusals. So any points based application, let's say a skilled worker application, you apply for it, it is refused, like I think someone asked over here, within, or let's say you apply for a graduate route visa that is refused, or student visa that is refused within 14 days. Okay, so there are 2 options. Any points based application is refused. One of the things that is written on that application refusal itself is you can apply for administrative review within specified timelines and all. You have that option, but admin reviews, so I will compare admin review against filing another application. What are the challenges of both of them? How section 3C comes into play, which one leads to an overstay, which one takes time, which one gets decided earlier. So these are several points I discussed with several of the clients over last, I think, 1 week or so. Many people asked me questions around this during consultations. So I have all the answers in my brain. I've analyzed everything. So just want to give it to everyone else. PBS application is refused, let's say a skilled worker, graduate, anything. Admin review right is always given. The bad side of admin review is that it takes up to 12 months, at least 12 months is the waiting time. One of the reasons is the admin review aspect. The admin review team is fully loaded with EU settlement scheme admin reviews. It is only one team who is dealing with PBS, EUSS, all admin reviews rather. EUSS admin reviews are stopped since last year August, yeah, from some time now, but there is a lot of backlog, and hence the admin review decision making time for any application refusal, skilled worker, graduate route, student visa, is still about 12 months or so. So waiting 12 months is practically almost impossible for many cases. Let's say a student, I don't think he will have a degree after 10-12 months. I don't know if his life moves on. Even for skilled workers, the job may not wait for him. Graduate route may be an option, but still 12 months is too much. So that is one of the concerns. filing an administrative review does give you section 3C leave. So till the 12 months, you do have your current rights. For example, if you're a student, you're switching to graduate route, that is refused for whatever reason. If you file admin review and it takes 12 months, approximately, let's say, I'm not promising it take, but I know most of the admin reviews, almost all of them take 12 months, 10 to 12 months definitely. So during those 12-month period, you will have section 3C leave. You will have full rights to work in the UK. Yes, you'll have full rights to work in the UK, right to rent, all those section 3C rights, because you file it within time, within the lifetime. The other side of it is you cannot travel outside the UK during that 12-month period. So I'm just talking of the pros and cons. Usually the main con is it takes up to 12 months. You are unable to travel outside the UK for that 12-month period. But the benefit side of it is you still have section 3C leave, and you can continue working in the UK till that AR is decided. The other option, instead of an administrative review, is filing another application. Let's say your skilled worker application is refused, and within 14 days of the refusal, you file another application, and that is section 39E, which allows. So that 39E says, if so, there are several things in that. I'll just point out one aspect of it. Within 14 days of refusal, let's say your application is refused on 31st of December, you can file from 1st January to 14th of January, you can file a new application, the same one or something else, doesn't matter, whatever you are eligible for. So let's say you file one skilled worker application or a graduate route application, let's take that example, that is refused, you file another one. The problem with that is, the good side of it is it will be decided quickly. It will take the normal timelines. Graduate route takes about 8 weeks. They will decide the new application. They will consider the new application valid also, because it is applied within 14 days. I'm not sure, not many people are aware of this, but this is a common thing that lawyers do use. We use in situations where applicant has done application themselves, and within 14 days we apply, we rectify whatever the problems were, and we improve on it, and we get the approval also. That is fine, but you get a decision very quickly. That is the advantage of it. Now the negative sides of it. So let's say your student visa expired on 30th of November, you filed in-time application for graduate route. Graduate route refused on 31st of December, within 1 month. Within 14 days, on 14th of January or before that, you file a new application, and you get a new approval on 1st of March with a valid visa. So from the end date of your student visa on 30th of November, in my example, till 1st of March, you are an overstay in the UK. So remember, that is an overstay. So that period, firstly about section 3C leave. If your application is refused on 31st of December, from next day onwards, you don't have section 3C leave, because you are not going for admin review. You are not continuing. You are filing a new application. So your section 3C leave ends on the date of refusal of the first application. Number one, you don't have right to work. That's the biggest point. You are not allowed to travel anyways, obviously. And the second part is, if you are trying to accumulate your years towards a 10-year long residence application, the period of permission ending, your student permission ending on 30th November, and your new permission granted on the second application on 1st March, about 3 months or so, that 3 months you cannot, it is called as, it is disregarded. It's a book-ended leave. It cannot be counted towards a 10-year long. It doesn't break your continuity of residence. You can still continue to qualify for 10-year long residence, provided you meet other requirements. But this 3-month period, you have to top it up. You have to do 10 months and 10 years and plus 3 months, and then you can apply for the long residence. So there is an important one. So I just wanted to compare two aspects over here. One is applying for administrative review. You maintain section 3C, but a lot of delay up to 1 year in getting a decision. But the advantage is you can continue working and all, but not able to travel outside the UK. And if you file a new application within 14 days of refusal, there is a break in continuity of section 3C leave. So you cannot work for a short period of time. Once your application is approved, the second application, then you can start working accordingly, whichever application you filed. And the effect on the 10-year long residence, that the 3 month, the period from your student leave ending, in my example, till you get the leave on the second application, that whole 3 month period will be disregarded from your 10-year calculation. So you have to do 10 years and 3 months on top of it. So all my updates are done. There are 2-3 questions. I may try to address them. Let's see. Habil, sir, what is the update on skill worker? Is it going to stop in future? No, it is not going to stop in future. Mahmouda Khan, we administrative review again refused. What option is available for graduate route? Administrative again refused. What option is available for graduate route? It really depends on the facts of the case. I cannot discuss all possible options. It depends on the facts of a particular case. If there are merits of it, it may be possible. If there are no merits, there is nothing possible. So I don't know. Admin review is also, as I addressed earlier, admin review is not just people just file it left, right, center. That's the reason it is taking so much. The queue is so long. Anyone and everyone is filing admin reviews because they don't have anyone. You just go online and you can fill it up in half an hour. You can submit it and prepare and submit. That's what people do. And the ARQ for outside UK and inside UK, it's the same queue. So don't file admin reviews unless there are merits. As I said, if I'm the caseworker, I refuse an application and there is an administrative error, I did not look at something. I think for Mahmouda, you did say that you did not pass the course of study and all. I don't think there may be much merits in an admin review in such a situation because the caseworker is not done anything wrong. There is no administrative error. So admin review only comes into play in an administrative error, a document not looked at, a page not considered, something like that. So Abil Khan, also my brother had a valid skilled worker visa cost, and had his appointment today. His course will expire 29 January. Is he late? 29 January. Will he get refusal? Chaos will expire 29 Jan. If he's already submitted the skilled worker application, course expiry date doesn't matter. The date of application, you will log the skilled worker date of application, so that's fine. Once you paid the fees of the skilled worker application, that's it. Doesn't matter if the course expires before a decision is made. Yeah, no. Hello sir, 9 December visa file but not a reply now. I remember Anna, you did ask this last time also. Yeah, as I said, wait, today, last time also I said, at least allow them up to 10th of January, I would say. 6th, 7th January, but there are a lot of holidays in the UK. So 23rd December you were interviewed. I'm not sure, but I don't want to scare you, but usually at the end of December, I don't want to give any scary information over here. So yeah, so just wait till at least 10th of January or so. That's my suggestion. Cortez Carter said, sir, my company applied for DCOS on 24/10. Mobis asked for more information of the company 5/11, but they didn't have us a final answer. Is it normal? Yes, that is normal. I think you asked this question in the previous live. That is normal. Okay, sir, thanks. Thank you everyone who joined the live. And yeah, you subscribe to the channel, consider becoming a paid member. If you do want advice about your specific situation, hit the link in the description and book your consultation with us. Thank you very much.